Kenyans will continue paying for the housing levy until January 10th after the High Court suspended its earlier judgment that found the law unconstitutional in what the three-judge bench termed as an allowance for the government to move to the Court of Appeal.
We have no doubt that this court has jurisdiction to grant orders of stay or conservatory orders pending appeal, even when it has declared provisions of law unconstitutional.
The decision was informed by a plea from the Kenya Revenue Authority, Attorney General and the Speaker of the National Assembly, Moses Wetangula, through their legal counsel for the judges to grant them a stay order for at least 45 days. Justice Majanja, Christine Meoli and Lawrence Mugambi ruled that they were of the view that they do not have the last word on the matter at hand.
We had a position that what is unconstitutional cannot have stay orders. You cannot continue to stay in an environment of sin just because somebody believes otherwise. Sin is sin before and after.
So you have to ask yourself, in a situation such as this, when the country has admitted that it is literally broke and on its knees, why would a court give such far-reaching stay orders without the benefit of having a formal application before it so that it can consider the case on its merits and then extend the validity of that stay for a period of close to 2 months? That for us is extremely strange.
In the earlier decision, the three-judge bench dealt a blow to President William Ruto's housing program after declaring the housing levy unconstitutional for lacking a compact legal framework upon which it's based on, being discriminatory and creating unequal principles. The court also had its ground that KRA was illegally collecting the funds in place of the exchequer.
That is their own opinion. We are convinced that when we go to the Court of Appeal, we will be able to establish a basis upon which the money is collected and how the money is going to be applied. But in the meantime also, Parliament will have to come onto its feet and consider whether we need to have another law onto which we will anchor the housing levy, and we'll also have regulations thereunder, which will be the administrative law as regards the money.
The court at the same time said the Finance Act 2023 is a money bill, and the argument that the concurrence of both speakers of the National Assembly and the Senate was required before the law was enacted does not stand. Although the judges found that there were anomalies in the passage of some sections contained in the Finance Act, they were not serious enough to negate the law. In the process, the judges upheld the 16% VAT on insurance premiums, the digital asset tax, and the tax on betting, saying they were constitutional and within the mandate of Parliament. The battle of the legality in the introduction of the housing levy continues in court. However, Kenyans in the formal sector may have to continue feeling the pinch until 10th of January or until the court pronounces itself otherwise on the matter. For K24 from Milimani, I'm David Kagina.